Chapter 25. Courts of England, Sec. 121. Court defined. According to Coke, Curia, court, is a place where justice is judiciously administered. This is practically Blackstone's definition. Sec. 122. Courts of record. Courts were classified under the common law as those of record, and those not of record. A court of record is a judicial, organized tribunal, having attributes and exercising functions independently of the person of the magistrate designated generally to hold it, and proceeding according to the course of the common law. Perry C. LPL. 21. In the earlier period of the common law, the records of such courts were made in parchment. Great dignity was attached to these records, such high regard being had for them that they imported absolute verity. Courts not of record originally were those courts a record of whose proceeding was not kept, enrolled or recorded as were those of record. Courts barren was an example, while a magistrate's court is an illustration in modern times. The distinction between courts of record and those not of record is a matter of importance, and prevails under modern law. The law presumes that courts of record have acted within their jurisdiction, it not being essential that all of the facts necessary to show that the court properly exercised its jurisdiction be spread upon the record. On the other hand, there is no such presumption indulged in favor of the jurisdiction of courts not of record, it being necessary that the record of such courts disclose all facts necessary to show that the court properly acted within its jurisdiction. Courts of common pleas are courts of record, magistrates' courts are courts not of record. A learned writer has said that a study of the origin and organization of the great common law courts has a more profound interest than a merely historical one. Adjective law has ever occupied a prominent place in jurisprudence. It has been said rights and duties are rather the adjective of procedure than procedure a mere appendage to rights and duties. Our common law is the law of courts which gradually acquired their jurisdiction by the development and interpretation of procedural formulas. Sec. 123. A consideration of the divisions of the courts in England. Legal scholars should give heed to the historical development of the common law and chancery courts. Particular attention should be paid to the transition of the courts brought about by the Judicature Acts of 1873 and 1875. Occasions are frequent in the life of the practicing lawyer when he must know something of the organization of the courts of England that he may make proper use and application of some English adjudications. Professor Hammond once observed that the English reports from the year-books down are unintelligible to the student unless he understands the former organization of the courts. The years intervening between the time of our separation from the mother country and now, have not established such a barrier between the two countries that we do not have to resort to English adjudications to assist in solving legal problems. A lawyer is a one who does not know the jurisdiction, character, standing and authority of the court pronouncing the decision which he uses. A magazine once reported a case of a lawyer of some reputation who in his argument to the court read from and commented upon a case reported in Brock, unmindful and ignorant of the fact that he was reading from an opinion of one of the ablest federal judges of the time. A system of reporting English decisions. It was during the reign of Edward I when the practice of the drawing up of reports of cases heard and determined, was begun. Legal historians state that there was no case law in the 13th century, that a previous judgment was not then regarded as a binding authority. Yet we find that the commencement of the year-books, from 1301-1509, the judges were occasionally insisting upon strict adherence to former precedent. Citation of precedents was not frequent in the year-books, it being difficult to discover the source from which their decisions were based. It was recited in the patent of King James I, by which the official reporters of the year-books were appointed, that the common law of England is declared by the judges upon cases that come before them, and that doubts and questions arising in the exposition of statutes are likewise explained and cleared up. This was a distinct royal recognition of decisions as law. This royal decree marked the beginning of the reporting of decisions, which began with the year-books. From the beginning of the year-books the doctrine of the common law has been that judicial precedents are to be followed in subsequent like cases. The life and soul of English law has ever been precedent. Case law is a necessary and indestructible part of every jural system, and peculiarly of our system. The publication of reports of adjudged cases will probably continue in the future, as in the past. without substantial restriction. The system of reporting English decisions was not conducive to a quick or ready understanding of the character of the decisions. In the original publication of the English reports there was no effort by any authority of the government, or by any of the reporters who edited the decisions of the particular courts, to adopt a name which would indicate or designate the particular court making the decision, but all of the original English reports were designated by the name of the reporter editing the volume. For example, the reports of the decisions by the House of Lords are designated by the names of 10 or 11 reporters. The reports of the Court of King's Bench and Queen's Bench from 1066 down to 1865 are designated by about 100 different names of reporters, while the reports of the decisions of the Court of Common Pleas are designated by 25 or 30 names of reporters. There have been republications of English reports arranged according to the division of the various courts, which set of reports show by what court a decision is rendered. It is practically impossible for anyone, however familiar he may be with legal bibliography, to know from the name of the original English reports, what court renders the decision, it being necessary, therefore, to gain that information to glance at the title page of the report and ascertain what court pronounced the decision. To form any reliable opinion of the character of the decision, and to determine what weight should be given it, we must have some knowledge of the courts of England previous to the sweeping changes made by the Judicature Acts of 1873 and 1875. For instance, when we are using a decision found in H. Blackstone, Bingham, Common Bench, Moore and Scott, all familiar reports of the decisions of the Courts of Common Pleas of England, we should know that the decisions found in those reports and pronounced by that court were not of final jurisdiction, but that they were subject to be reviewed on writ of error, or in the nature of an appeal to the Court of King's Bench or Queen's Bench. And so must we know that the decisions of all inferior courts of England, whether it be the Court of Exchequer, or the Court of Exchequer Chamber, or Cyprius Court, are all subject to be reviewed by the Court of King's Bench. This argument shows some necessity of a knowledge of the organization and jurisdiction of at least all of the principal courts of England. A lawyer should study a decision from all standpoints. He should consider not only the principles of law enunciated, but also the character and standing of the court and of the judge delivering the opinion. Enough has been said, it would seem, to justify a brief reference to the organization and jurisdiction of the various courts of England prior to and since the Judicature Acts of 1873 and 1875. As a matter of fact, there is more real good to be obtained by the American student from a study of the practice of the courts of England as they were constituted prior to the acts above mentioned, than since. Professor George Chase, writing upon this subject, well says that, the ancient English practice was the basis upon which the procedure of the American states was originally founded, and may, therefore, be reasonably considered of more value to the American student, than that which has since been introduced in England in its stead. It is true that, in the various states, important changes have been made in the early systems of legal procedure, so that now there is no little diversity in this respect, but a statement of the methods of practice, in which there was formerly essential uniformity in the different states, will be of more practical value to students in different parts of the country, than an account of the present practice in any particular state. There is such a general correspondence between all systems of practice, that every student will find Blackstone's account of the principal rules of practice and pleading of much importance as an introduction to the study of the procedure in his own state. Sec. 124. Courts of England, continued. In the earlier periods of English history the difficulty was rather in the way or manner of obtaining or maintaining one's rights than in conceiving what they were. It is only in the most recent times or in the most highly developed legal systems that remedies have lost importance in comparison with rights. Our common law is the law of courts which gradually acquired their jurisdiction by the development and interpretation of procedural formulas. The courts of most importance were the Court of Common Pleas, the King's Bench, and the Exchequer. The first step towards reform was taken by King John when he granted a clause in Magna Carta, establishing the Court of Common Pleas, hereafter referred to. The law thus promulgated by King John was one of the most potent steps towards the unification of the common law and the consequent overthrow of Roman methods. Bitter controversies between those favoring and those opposing Roman methods had been previously waged. The efforts to transplant Roman ideas served as a strong incentive to improve the laws of England. Up to this time they had been dealing with their own traditions and customs, and had not been indulging in that most useful process of making law comparative jurisprudence. Their method of lawmaking continued its operation with more or less influence and absorptions from the revival of the Roman law, in 1150, until the law took definite shape and system under the reign of Edward I. About the time of the grant by King John, making the People's Court stationary at Westminster, the study of law as a science was begun under the direction of a society formed for that purpose, which purchased buildings near Westminster Hall, and which afterwards became the Inns of Court. But the work of the Romanists went on, and the comparative processes in the hands of the common law adherents were still used until the final victory under Edward I. A definite system of law was formulated by Edward I, who reigned from 1270 to 1307. It was at this period that the common law as developed in later ages had its inception. This monarch prescribed the limits of the courts, the King's Bench, Common Pleas, and Exchequer, so that they would not interfere with each other's proper business. He settled the boundaries of the inferior courts in counties, confining them to causes of no great amount. He guarded the common justice of the kingdom from abuses, by giving up the royal prerogative of sending mandates to interfere in private causes. He first established a repository for the public records of the kingdom. The very scheme and model of administration of common justice between party and party was entirely settled by this king, and has continued nearly the same, in all succeeding ages to this day. The forms of writs, by which actions are commenced, were perfected in his reign, and established as models, for prosperity. He limited and established the bounds of the ecclesiastical jurisdiction. The work of King Edward in the adjustment of the courts and their jurisdiction, and the provision for the records, is what gave birth to uniformity of decision, making the law of one court, the King's Bench, the common law. There was created a court of appeal whose decisions were binding upon all courts of inferior jurisdiction as well as upon itself. The provision of Edward I, for the keeping of the records of courts, necessarily gave rise to a system of reporting decisions, and a system of reports follows as an indispensable auxiliary to the uniformity of judicial precedent. The oldest reports extant on the English law are the yearbooks, which consist of 11 parts or volumes, written in law French, and extend from the beginning of the reign of Edward II, 1307, to the latter end of Henry VIII, 1509. Sec. 125. Court Baron or Manor Court. This was a court incident to every manor in the kingdom, to be holden by the steward within the manor. It entertained pleas in personal actions of debt, trespass on the case, or the like, where the amount involved did not amount to 40 shillings. There were two divisions of this court, one, the customary court baron, the other the freeholders' court baron. The former exercised jurisdiction over the transfer and surrender of copyhold estates, and the latter of writs of right to land within the manor. These courts were superseded by the County Courts Acts of 1846 and 1867. Sec. 126. County Courts. The jurisdiction of these courts was coextensive with that of the sheriff. The freeholders of the county were the real judges, and the sheriff was the ministerial officer. This was a court not of record, and was the most ancient, the most active, and said to have been the most important in the kingdom. It exercised jurisdiction over civil, criminal and ecclesiastical matters, in this court causes relating to title to land, the right to titles, or bargains and sales of land, of services and customs. Acts were passed in 1846, 1849, 1950 and in 1888, materially modifying the jurisdiction of this court, but increasing its usefulness. Sec. 127. Court of Common Pleas. This court was brought into existence through reforms brought about during the reign of King John. A provision was made in Magna Carta, A.D. 1215, that, communia placita non sequentur curiam nostrum, Stensent is an alico certo loco. Common pleas shall not follow our court, but shall be held in some certain place. This court retained its name and place until 1875. It was, in more recent times, composed of a Chief Justice and 5 puisne justices. Its jurisdiction was original and embraced all civil actions of all kinds between party and party. At a later period the Court of King's Bench, and the Court of Exchequer assumed jurisdiction of all personal actions between subject and subject. All actions were commenced in the Common Pleas Court by means of the original writ, the theory being that the king was the fountain of all justice. This court exercised exclusive jurisdiction over what were distinctively real actions, and of other actions provided by statute. Pleas in this court were divided into 2 sorts: pleas to the crown, which comprehended all crimes, and common pleas, which include all civil actions between subject and subject. Pleas to the crown were committed to the jurisdiction of the King's Bench, while common pleas were within the jurisdiction of the Court of Common Pleas, which Coke said was the lock and key to the common law. Sir Orlando Budgeman designated this court as the common shop of justice. Mr. Perry states, the early establishment and localization of this court at Westminster gave rise to the Inns of Court in its neighborhood, and collected there the whole body of the common law lawyers, thus strengthening the law itself, promoting its development, and enabling it to resist the attacks of the canonists and the civilians who labored to substitute for it the system of the civil law. Sec. 128. Court of Exchequer. Originally this court had jurisdiction only of cases which concerned the revenue of the crown. The government prosecuted causes in this court for the collection of revenues, either in the form of an action at law or in equity, according to the nature of the case. No original writ was necessary to commence an action in this court. The powers of this court were, in course of time, extended and, in addition to the enforcement of the royal revenue, another division was added, known as the Exchequer of Pleas. In this division the court exercised jurisdiction in personal actions by and against its officers and attorneys, and accountants of the king, to whom was accorded the privilege of suing and of being sued only in their own court in all personal actions. This court assumed jurisdiction in all personal actions between subjects, by a resort to a fictitious source of jurisdiction, which was confirmed by Act of Parliament. In 1842 Parliament limited its jurisdiction in equity to matters arising in connection with the collection of revenues. The jurisdiction in equitable matters generally was transferred to the Court of Chancery. This court was inferior in rank to both the Common Pleas and King's Bench. Sec. 129. Court of Exchequer Chamber. This court was created by Statute 31, Edward 3, c. 12 to determine causes upon error from the common law side of the Court of Exchequer, and was made up of the Lord Chancellor and Lord Treasurer, taking unto them the justices of the King's Bench and Common Pleas. From all the branches of this court error could be prosecuted to the House of Lords. Sec. 130. Court of Assize and Nisi Prius and other courts. This court was composed of 2 or more commissioners, who were, twice in every year, sent by the King's Special Commission all round the kingdom, except London and Middlesex, where courts of Nisi Prius were held in and after every term, before the chief or other judge of the several superior courts. In the 4 northern counties the assizes were held only once a year. These courts tried by a jury, in the respective counties, the truth of such matters of fact as were in dispute in the courts of Westminster Hall. Afterwards this court was directed by Magna Carta to be sent in every county to receive the verdict in certain actions then called recognitions or assizes, the most difficult of which they were directed to adjourn into the Court of Common Pleas to be the determined. There were other courts or commissions such as, 1. The Commission of the Peace. 2. A Commission of Oyer and Termina. 3. A Commission of General Gold Delivery. 4. A Commission of Assizes. Then there were ecclesiastical courts, military and maritime courts. The ecclesiastical courts were divided up into 6 different divisions presided over by different authorities in the church. Matrimonial causes, or injuries respecting the rights of marriage, was the principal branch of ecclesiastical jurisdiction. Sec. 131. Court of Kings, or Queen's Bench. This court was so named because originally the king sat there in person. Though the king was supposed to sit in this court, he was not empowered to determine any cause, but by the mouth of his judges, to whom was committed his whole judicial authority. This court was the remnant of the great royal court, all egregious. It exercised a supervisory control over inferior tribunals by means of extraordinary writs of mandamus, quo warranto and prohibitum. It exercised jurisdiction over criminal matters of all kinds, both felonies and misdemeanors. It also had jurisdiction over civil matters in all personal actions against all persons. One of the most important functions of this court was in entertaining appeals from the common pleas and all inferior courts of record. Appeals were also taken from the King's Bench to the Court of Exchequer Chamber or to the House of Lords. In civil matters the jurisdiction of this court was originally limited to that class of wrongs for which also criminal prosecution could be had, this jurisdiction extending throughout the kingdom. Actions of this kind were commenced by means of original writs issued out of chancery. Originally no action of debt or detenue, or other mere civil action, could, by common law, be prosecuted in this court by any subject by original writ out of chancery, except the action of debt given by statute. Finally, however, it came to exercise jurisdiction by means of original writs in all personal actions against all persons, excepting prisoners, and officers or attorneys and peers of the realm and members of the House of Commons. Sec. 132. The House of Peers or House of Lords. This is the Supreme Court of Judicature in England. It has jurisdiction only on appeal or error to rectify injustice or mistakes of law committed by the inferior court. This court was composed only of the law lords or the peers, who, at the time, held judicial positions, or who had before held such positions. Sec. 133. Court of Equity. Causes leading to establishment of relation of Roman law and early English law. There always existed the closest relations between Roman jurisprudence and the early English common law. Writers upon the history of law in the different centuries have differed very materially upon this question. Blackstone and Coke, in tracing the origin of English law, did not trace it back to Roman law, while some of the more modern legal scholars have shown a close relation between the two systems of jurisdiction. A striking similarity between the two systems in very many matters is readily discovered by the careful student of the history of law. This is shown more particularly in the adjective law, although it is quite apparent in many branches of substantive law. There were, from an early period of the Roman law, 5 actions for the enforcement of all civil rights, which required absolute accuracy in pursuing them to avoid fatal errors. There was a strong analogy between these actions and the old actions of the common law. In the work of constructing a jurisprudence, the early common law judges, as well as the chancellor, drew, to some extent, from their own knowledge of the Roman law. The principles of Roman jurisprudence entered into the common law in its earliest formative period. This was natural when we consider that the earlier common law and equity courts were presided over by ecclesiastics. These justices and chancellors, being familiar with the Roman law, in the formation of English jurisprudence naturally drew from the doctrines of the Roman law. Some of the earlier common law judges fought, with considerable tenacity, any modification of doctrines and rules established by them or any relaxation of settled methods by which rights were to be secured or protected. It was next to impossible to expand or improve common law procedure because of the ironclad determination of common law judges to adhere to their own forms of procedure. This was one of the principal causes which led to the establishment of a separate independent court of equity. Nothing further will be said at this point with reference to the history or jurisdiction of this court, a more detailed discussion of which will be made in another connection. Sec. 134. Reorganization of English courts. By the Judicature Act of 1875, 38 and 59 Vict. C. 77, all of the existing courts were declared to constitute a single tribunal, known as Supreme Court of Judicature. This is divided into 2 divisions, viz., Her Majesty's High Court of Justice, and Her Majesty's Court of Appeal. The first named court has original jurisdiction and the latter only appellate. The appellate jurisdiction of the House of Lords is retained, and it hears appeals from the Court of Appeals and from Irish and Scotch courts. It is in fact the Supreme Court for Great Britain and Ireland. Though the entire House of Lords constitutes nominally the final Court of Appeal, yet in practice the exercise of the judicial functions is confined to a small number who are called Lords of Appeal. The Lord Chancellor is one of the number, while the others are usually such as have occupied high judicial honours. 2 are especially appointed. There were 9 judges in the Court of Appeals, 5 ordinary judges, and 4 ex officio. Those who are members of the court by virtue of the offices held by them, are the Lord Chancellor, Master of Rolls, Lord Chief Justice of England, and the Judge of the Probate Court. The High Court of Justice is divided into 5 divisions corresponding to the previously existing courts, which exercised original jurisdiction. In 1881 they were consolidated into 3 divisions. The 5 divisions into which the High Court of Justice was divided were designated as the Chancery Division, the Queen's Bench Division, the Common Pleas Division, the Probate, Divorce and Admiralty Division. The division into which the court was reduced in 1881 is as follows: Chancery Division, Queen's Bench Division and Probate, Divorce and Admiralty Division. The Exchequer and Common Pleas divisions were consolidated with the Queen's Bench Division.